Some of you have asked questions about, if a property flooded in certain years, yes or no. And some of that gets into the conversation of disclosures, what do we disclose? And if your son or daughter was the buyer, what would you like to be disclosed to them? And so Fred is going to talk a little bit about that and, concerns potentially about legal risk that any of us might face when it comes to disclosure. So Fred Xlander.
Thank you, and good afternoon, everyone. My role here is to talk about the disclosure responsibilities of the various parties to a real estate transaction. So let's start with the seller. Prior to 2002, the seller really had very little disclosure responsibilities. The only thing the seller couldn't do is outright lie regarding a question that is put to the seller. By the way, I have a handout that I think most of you got. If you don't have it, maybe Jim can. I have a few in the box back there, Jim, that maybe you can distribute for people who don't have it. That handout, by the way, has three cases in it that is relevant to our discussion here today, and I'll comment on those in a moment. But prior to 2002, the seller had very little disclosure responsibilities. If he was asked by a buyer or buyer's agent, did this property ever flood? Then the seller had the responsibility to answer that question truthfully, yes or no. But other than that, there was no other responsibility. Even silence back in those days, and even to some extent now, was not considered a fraud. So if the seller, prior to 2002, knew that the property flooded but didn't say anything about it, didn't reveal it to anybody, that was considered not a fraud, not a misstatement, not a withholding of information, because silence in the law at that time was not viewed as a fraud. Then in 2002, what happened, the Property Condition Disclosure Statement came into being, the PCDS, and what that did was it forced the seller to make statements, right? They couldn't be silent anymore. They had to answer questions 10, 11, 20, 30, and 31, which deal with the water issues and flooding issues and so forth that may occur on the property. So as of 2002, our sellers now have to reveal what they know truthfully, and the only responsibility of the listing broker at that point is to encourage the seller to answer the questions, answer them truthfully. The listing broker has no responsibility to do anything like check the answers, check the work of the seller, challenge it, or anything like that, just that the disclosure is filled out. Now, in your handout, it's an 8-page handout, and on page 3 is a case. It's called Kasmark against Waslin. Kasmark against Waslin. This is a case that is from our area, from Broome County. It was decided by Judge Levis on the trial level, and then went up to the Appellate Division, 3rd Department, which is the Appellate Division for our area. So what happened here is that the seller, Waslin, bought the property in question, and this was at 1414 Flores Street, if you know where that is in the town of Union. It's out in the West Corners. And we know how badly that was hit in both 2006 and 2011. But it's a West Corners area property, and the owner, seller, bought it in 1999 and owned it at the time of the 2006 flood. And it got badly damaged in the 2006 flood. After the 2006 flood, Waslin completed a bunch of improvements on the property, redid the foundation, grading, gutters, all kinds of things to improve the prospect of not being flooded again, at least to the extent and all the damage that occurred in 2006. He owned the property a couple more years, 4 more years, and sold it in 2010 to Kasmark. Of course, a year later, the 2011 flood came, and this property on Flores Street was severely damaged again by the flood. Kasmark goes back to his PCDS in the contract, and he looked at questions 10, 11, 20, 30, and 31, and the seller in that situation or on those questions answered negatively as to any impact of flooding or water damage or anything like that, claimed there was none. So Kasmark does the good old American thing and sues Waslin, and it goes to trial. And Waslin's defense was, well, I answered to the best of my knowledge based on what I did after 2006. I thought I repaired everything after 2006. And between 2006 and 2010, when I sold the property to Casmark, nothing happened. I mean, I didn't get any water in the basement. There was no flooding or anything like that. In our normal storms during those periods, those years, everything was fine. But then we get the abnormal event of 2011, and it was a disaster. That was the defense. And guess what? The court bought it. Judge Levis dismissed the case against Waslin, the former owner, the seller, based on that theory, that this individual answered in good faith based on what they knew at the time of the closing, or near the time of the closing in 2010, as opposed to what he knew in 2006. Casmark takes it up on appeal to the Third Department, and the Third Department affirmed Judge Levis's ruling. So I guess what we take from this is that the courts are not particularly friendly to PCDS issues. They're just not. And I'll express a theory on that in a moment. But the courts tend to side with sellers in their disclosures of these things, as you can see from this example, where the court said, oh, well, he thought he had it fixed and everything was okay, so what else is he going to say? Now, why do the courts do this? And in the other two cases, you're going to see sort of a thread of this as well. I think it's because the courts do not like the PCDS. And they don't like it because who created it? The other branch of government, the legislature. The legislature created that PCDS, and the courts feel that it is an inadequate document, especially because it has what on there? The unknown checkbox. So that people can sort of waffle in their answers and really get away with giving incomplete answers. And the courts, I think, don't like that. They feel it's an inadequate document, and they just basically are not enforcing them against sellers to any significant degree. Now, I said that the listing realtor has a responsibility to get the PCDS filled out, to encourage the seller to do it truthfully. But other than that, the listing realtor has no further responsibilities. Other than, and I tend to preach this one before realtors, and that is to give them the option, make sure they understand, that sellers understand they have the option of giving a $500 credit and buying themselves out of liability and buying a listing realtor out of liability for that matter as well. And for the life of me, I don't know why we don't do that more around here or in the GBAR region. Now, I was talking to some realtors last week, and the answer that I usually get is, well, buyers get suspicious when the PCDS is not filled out. Well, it works one county over in Delaware. It works through much of the state of New York. I don't know why it couldn't work here. I guess my only thing I can say and encourage you to do is at least discuss this option with the seller. I think it's a good option and one that should be taken seriously by the seller and kind of gets rid of all this disclosure issues that tend to come up. Now, while the listing broker has no responsibility to check the work of the seller or anything like that in the answers of the PCDS, they also cannot make known false statements. I think that's kind of a given. I think we all know that. But if you go to the first case on pages 1 and 2, and that's actually a digest of the case is much longer, but I just gave you what was necessary here. If you go to the bottom of page 2 where it says breach of fiduciary duty seller's agent, if you look at that paragraph, and toward the bottom there is a very succinct statement from the court in this case, another New York court, that simply says this: New York imposes no duty on either the seller or the seller's agent to disclose any information concerning the premises. So from a listing realtor's point of view, you have almost no responsibility to do anything in terms of disclosure, and frankly, neither does the seller. And part of the reason for that is if you go up to the underlining part in the middle of the page there, take a look at that language. Further, if the facts represented are not matters peculiarly within the party's knowledge, and the other party has the means available to him of knowing, by the exercise of ordinary intelligence, the truth or the real quality of the representation, he must make use of those means, or he will not be heard to complain that he was induced to enter into the transaction by misrepresentation. What they are saying here, what the judges are saying in this case, is that if the buyer can do their own due diligence, get on Broome GIS, get an inspection. Who doesn't get an inspection now, right? Through these independent means, including even knocking on neighbors' doors, which I've had clients do, and some people have more fortitude to be able to do that than others, but I've had clients that have literally gone through the neighborhood to ask questions of neighbors. If you can get information independently on your own that way, then you're not relying on what a realtor says, you're not relying on what the seller says. You have to do your own due diligence is what the court seems to be saying here. And there's another case that we'll follow up with on that as well. So disclosure with the listing agent, not much. How about the dual agency? That's a little bit more complicated, right? And that's a fairly common situation, the dual agency. And under real property law, section 443, you know, of course, that you have to have a disclosure filled out by both parties, buyer and seller, agreeing to the dual agency. And supposedly, anyway, that causes them to understand that the realtor in a dual agency relationship doesn't have the same confidentiality or loyalty to either party as that realtor would have in a non-dual relationship, correct? So in the dual agency, this gets kind of tricky because if you're representing both parties, don't you have some responsibility to talk to the buyer about what might have transpired with the property, you know, like in West Corners that we were talking about, Flora Street? And I think the answer is yes, there is some responsibility, but how far do you go? I think you go at least as far as encouraging that buyer to do the things I just said, get your inspection. I'll tell you, these cases all pretty much absolve everybody of responsibility when there's an inspection involved. Get an inspection, talk to the neighbors, get on Broome GIS or whatever FEMA website you might be able to do. Maybe help the buyer do that, suggest these resources. But you also have some responsibility to and duty of loyalty to the seller as well, right, in these kinds of arrangements. So how far you go, I think, is sort of on a case-by-case basis, but you have some responsibility to both parties and certainly to the buyer in that situation as well. And then as a buyer's agent, which is a little more rare, but it happens, there's undivided loyalty owed to the buyer. And if you look at the third case in my handout here, that would be on page 6, yes, the Gallagher case on page 6. This involved a suit against a bunch of people, including Realty USA. And if you look on page 8, actually, and you look at the last paragraph, where just above the ordered sentence here, just above ordered, it says there that by this court that we agree with Realty USA that it had a duty not to conceal or misrepresent known facts, but that it had no duty to investigate unknown facts. Truthfully, I'm not exactly sure what that means, but it does show that the courts are not, desirous of putting realtors on a hook for the condition of property. It's either going to come from the seller through the PCDS or these other factors that we've been talking about today, websites, and particularly the inspection. And if you go to the other column, to the left column on that same page, page 8, at the top, you'll see the sentence next to the citation. It says, although the Ruzines, that's the seller's property condition disclosure statement, was silent with respect to any water seepage or water dampness in the basement, plaintiff's home inspection report put them on notice of that issue. And plaintiffs therefore cannot assert, in other words, the buyers cannot assert that they justifiably relied on the fact that the seller's property condition disclosure statement failed to mention the water damage. So really, I guess the answer in all these disclosure issues and questions is buyer, get an inspection, and you all recommend that. And once that inspection is out there, the PCDS and any statements by any realtor are pretty much irrelevant in the court's minds and are not going to be taken into consideration, like Casmark in the West Corners case. And the buyer is going to be responsible for their own due diligence. So in the final analysis then, what are we really talking about? I don't think we're talking about disclosure so much as we're talking about discovery. And it's really the buyer's responsibility of discovery that the courts are really taking buyers to task on. No buyer in all of these three cases brought by buyers won in the courts. They all lost. And by the way, Casmark was just decided about a year ago by the third department. It was decided in December of 2018, so it's a pretty recent case, just about a year ago. When did the 2011 flood happen? 2011. We get resolution in 2018 in the courts. 7 years. So you can see how inefficient the court system is, how inefficient a lawsuit is. No matter how mad people get, say, I'm going to sue you for everything you got. Yeah, be my guest, and maybe 7, 8, 9, 10 years later, you might get a decision. It's probably not going to be favorable based on these cases. So really what we're talking about is not so much disclosure by sellers and realtors and all that. We're talking about discovery by the buyer, who really were still, even though NAR literature and so forth kind of says this isn't true, it is true, that New York is still a caveat emptor state, a buyer beware state, and the buyer has to take care of their own selves and do their own due diligence, do their own discovery to determine the quality and history of the property, whether it's flooding or really anything else. Also, a lot of times you hear, and I'll wrap up with this, occasionally you hear, and you don't want to be this, and probably nobody in this room does this, but occasionally you hear a realtor say, oh, you don't need flood insurance, or make an opinion about flood insurance. That's not for me, that's not for you, that's for those guys back there, for Jim Rollo and his staff, to advise you on flood. Everybody's got their own professional corner here, right? Me, title and closing and law, you guys marketing and pricing and getting inspections done, and Jacques doing the mortgage and telling you what is required there, and Jim telling you about flood insurance and what the rates are going to be and things like that. The other thing, as long as I'm on it, once in a while I do hear a realtor, I hear lawyers sometimes say, you don't need title insurance. Don't say that. Let that be our corner, just like Jim has his corner, and we'll talk to the client about the need or non-need for title insurance on any given property and what that property tends to show us might be the need or the non-need. Okay, that's it. Any questions? Yeah.
So in regard to the property condition disclosure and the question in regards to seepage, if somebody sees a yes that there's seepage, granted maybe that seepage disappears quickly, in the basement, whatever. I think that it states that if you answer the question yes, that you can go on to page 4 or page 6, depending on which property condition disclosure you're using, to further explain what happened either in 2006, 2008.
Right.
Don't you suggest that the seller go a little bit further and explain what might have happened there?
Sure, I suggest that. You would too. The question is, will they, do they, what are they trying to hide? And they do, you know. And that was what the Casmark case was really all about. And the court wasn't very sympathetic to it. I mean, the court threw the buyer's claim out. I think in Casmark, if I was advising that seller, I would have said, go to page 4, go to page 6, and explain this a little bit. In the last few years, you didn't have flooding. But what happened in 2006, and what did you do to improve it? I would have, but the court said that wasn't necessary. Anything else?
I'm not real sure about the waiver.
About the
How does
waiver?
How does that release the seller of all liability and fraud of notice of that?
Repeat the question, Fred?
Yeah, the question is the $500 credit, how does that relieve the seller from all claims of fraud? The short answer is that the courts have said that. The courts have ruled that if the $500 waiver, well, the $500 credit is given, then the seller has essentially bought themselves out of liability. It's by court decision. Now, you raise a good point. It is not impossible that even with the $500 credit, that a court could find that there was really active concealment, just kind of gross misrepresentation. It is possible. But boy, given my reading of the cases, it is extremely difficult to convince a court that the buyer relied on those, didn't do other things, or if they didn't do other things like get an inspection, that they're not sort of liable for their own problem. But the short answer to your question is, it is by court decision that the $500 given in a credit takes the seller out of liability 99.9% of the time. Yeah.
Fred, how long can a buyer go after them? Like, how long is that liability in place?
6 years. Yeah.
Yeah, Fred, in most cases, there's gonna be a home inspection.
Right.
Probably should be.
Exactly.
Certainly, that's going to help the buyer determine some of these issues. And that,
Absolutely. And that's what I mean. I mean, if you get the buyer has to get that home inspection and take that to its logical conclusion, whatever the report says, and then continue on in the discovery process. And it really is a discovery issue anymore on behalf of the buyer to find out what's wrong with the property. You can't be relying on statements by sellers, realtors, or anybody else.
right. Thank you.
Okay? Yeah.
So I just had a client who was an attorney that I showed him the property disclosure, and he kindly handed it back to me, and he said, I won't sign this, I'll pay the $500. So why would you sign, or would you fill out a property disclosure?
No,
I wouldn't.
I would not.
So why are we handing these out if?
My question exactly. I don't know. Well, and the other thing too is that, again, you go over one county to Delaware, they frequently use the credit and not the PCDS. And other places around us, Long Island, never. It's the culture that we have here to fill out the PCDS. I think we should change that. Yeah,
So it almost sounds like a fiduciary for the seller that less is more in this circumstance with them, right?
yes. That's generally true, I think. Yeah, back there.
So when we have the disclosures filled out, we upload them to the MLS, they stay there forever. How do you feel about that? They stay as attachments on all the previous listings.
How do I feel about that? I don't like it. I'm not sure what the policy is that brought that about.
Because they're attached.
Yeah,
But as a buyer agent, you're doing research and
Right.
let the appraisers use them. The
Right.
appraisers look at all the old
right. I'd have to think about that more, but I think in general, my initial reaction is, why are you doing that? I don't think that's necessary. I don't like it. I think that each transaction rises and falls on its own, and I would be adverse to it. Yeah. Okay, anything else?
Questions? Anybody?
Adverse to closing the disclosure?
Adverse to keeping them there forever, I guess.
We don't have any control.
No, you don't. You don't. All right, thank you, everyone.
Thank you.